like to do is engage everybody here in a conversation. So the order is going to be first Deborah Post, second Ariela Gross, third Pat Williams, and fourth Lenora Ledwon. And each of them can introduce themselves in any way they can.
Okay, I'm Deborah Post. I am a professor at Touro Law Center and the Associate Dean for Academic Affairs and a co-author with Nancy and with Amy of a casebook, Contracting Law, which has actually been around for quite a long time now. 20 years, maybe?
One of the products.
Yeah, that's the contract book, so anyway. Ariela used to use our book and actually wrote a short piece about why she chose to adopt a different casebook and use a different strategy than the one that we chose in the casebook that we have, which is explicitly, I like to say, other-centered and critical in its perspective, and which uses not only history and social science in some places, but also literature. So I was preparing for this conference, and, well, you call it preparing. I was thinking about what I was going to say at this conference, and lo and behold, Nancy sent me a post that was on Prof Law blog about the controversy that's going on at Albany Law School. And in it, one of the comments came from a student at Albany, a former student, an alumnus of Albany, who claimed that there were some law professors who really should retire, among them Nancy, because he had to study contract using our casebook. And in particular, he was much offended and thought that he wasn't prepared to be a lawyer because we started the casebook with a case from the Kingdom of Hawaii rather than with the Carbolic smoke case. Right? So apparently, 1892 in England, right, a case which is about whether or not an ad can be an offer, that's decided in the middle of the Spanish flu epidemic, a la Dalton Abbey, is more relevant, right, than a case that was decided around the same time in Hawaii, true, but by a judge who was from New Hampshire and who was trained at Harvard College. And I have to say, I think there are many people who have used our casebook who've never taught the Hawaii case. I teach it every year. And I love it because I think it's one of the most modern cases that there is out there for 3 reasons. First of all, the case, although it's a contract labor case about Hawaiians who entered into a contract to work on a plantation, who then breached the contract and who were being prosecuted criminally. The case is styled as a contract case, and the judge discusses mutuality of obligation, right, agency theory, and the doctrine of uncertainty and indefiniteness, right? So those are all 3 things which we cover in a traditional contracts class. And what was interesting for me is that I thought it was consummately modern for a number of different reasons. One is that in justifying the enforcement of the contract, the criminal penalty, which is forced labor for the contract, and the discussing the whether or not the mutuality of obligation defense would work, the court said, in a kind of pragmatist, law and economics, reduced transaction cost way, that they shouldn't and couldn't enforce a provision which would make it difficult for planters to run their operation because the argument was that the agents should get written authority because there's a criminal penalty if you breach the contract, right? And the court said, and by the way, nobody ever enforces that criminal penalty. This is in the context of a case, right, where the workers are being punished in a criminal context. So at the same time that the court took this very pragmatic approach, it inscribed or embedded deeply in the law the asymmetry, right, between the planters with whom the state identified and had a shared interest, right, the growth of the And then secondly, with respect to this uncertainty doctrine, the court did something which I think we would all recognize. The provision in the contract said something like the employees had to do whatever the owner of the plantation said they had to do, which is like, what is that? Jump off a cliff, right? What are the limits? And the court then constrained the discretion of the owner by saying, well, what that really means is that they have to do what is reasonable and necessary. Doesn't it sound really legal, realistic, or discretion like this, right? To do what is reasonable and necessary in the business, right? And in terms of what is reasonable and ordinary acts of labor on a plantation. Right? So this is what, 1870s or something like that. But an amazing decision, I think. So for me, I can always say, remember Puaiki, right? When we get to uncertainty and definiteness, when we do mutuality of obligation, and Puaiki does stick in their brain for one reason or another. But I have to say that it's not the first time that our choices have been ridiculed, and among the reasons why we've been ridiculed, I remember somebody in a contracts conference who was a speaker who referred to the fact that we had the lyrics from Love Me Tender next to the case, which was the lawsuit by Ginger Alden's mother against Elvis Presley, who obviously somebody who doesn't appreciate irony, but that's okay. And I always thought that it's interesting that also to juxtapose those lyrics with a case which documents so clearly the economic aspects, right, of both courtship and marriage, right, where there is an exchange of wealth. I always like the case because it's a promissory estoppel case, and the court says, well, you should stop relying when you die. And I thought, well, promissory estoppel is the same as contract. Once an offer is accepted, right, the contract is binding. If you have promissory estoppel and somebody's relied, why isn't it binding, right? And then I realized that perhaps what they were talking about was the principle of mitigation, because they were saying essentially you shouldn't have continued to rely, right, after his death, and maybe that's like mitigation. I'm not really sure. Okay, so I'm not saying much more, so it's okay. So I found that it was both sort of temporally and doctrinally challenging to try to teach this case and explain why it is the mother could no longer rely on the promise that was made after she had already relied by filing suit, entering into a settlement agreement with her husband, obligating herself to buy out his interest in the house, and then Elvis Presley dies, and the lawyer who was representing her, who was representing the estate, said, I can't represent you anymore, I'm walking away and the estate's never going to pay me. So the trial court, I just have to say, there's one citation in the case where the trial court says something like, you already got a lot from Elvis Presley, be thankful, go away, right? Which is a recognition, right, of a wealth exchange that took place. And I have to say that that Elvis Presley probably my students don't relate to, but you know what they do relate to? Kanye West. So I always use Gould when I teach that case, which is a horrible song, but it's basically the premise of the trial court when it said, that's it, right? You don't get any more, you got all you're going to get from Elvis Presley's estate. So my last thing is that I just want to say that when we wrote the book, we were self-conscious about a couple of things. We were writing it at a time when the sensibility in the academy was that we wanted to introduce race, gender, and class into the curriculum, recognizing that we had a more diverse student body, right? And we had a more diverse faculty as well. So, but the point of it was not necessarily, all right, 1 minute, I'm going fast now. The point of it, besides enriching the material, we have historical materials too, and in fact, Hawaii is run by Ron Takaki's piece about the contract labor and why. But it was also to let the voices be heard of the people who don't get to to the extent that we had cases where people of color and women and others were, the facts were being described by the judges, we wanted to have some literature that actually might expose students to the lived experiences of those people who were parties to the lawsuit, but where the courts might have lacked the imagination or ability to, and certainly in their narrative, to describe the circumstances of those people adequately. So we also included, and here the last point is that we also wanted to include, and I was a big proponent of this, to give us some legitimacy, the voices of, in the canon, excerpts from the canon of oppositional voices, white male oppositional voices. So we have Steinbeck, right? We have other excerpts. Oh, Henry, yeah, right, who went to prison. So we have excerpts in the book that are meant to show that this is part of your culture too, right? Your culture is not just what's hegemonic, it's also what's oppositional. And you can choose, right, which perspective you want to embrace. So anyway, that's my presentation. Thank you. And thank you, everybody.
So I'm Ariela. I teach contracts and legal history at the University of Southern California, together in one place. And I'm really thankful that Deborah and Jennifer thought about putting this together to have this conversation. And as Deborah said, it started from my thinking about this started from a panel that was at the AALS a few years ago about introducing humanities into the first year curriculum. And so it was actually people talking about a bunch of different first year subjects, and I was talking about contracts, and I realized that when I was starting to think about my own experience that a lot of it was a story about my own failure as a teacher, really, because I was not successful using Deborah in the casebook, although I love the casebook. I love the approach. I love all the materials. I mean, I was very excited to teach out of the casebook. I wanted to, I was at the time writing a book that was very much about commercial law in people's day-to-day experience and the way the intersection of law and local culture in commercial law, in this case commercial law of slavery, helped us see the way people made race in their everyday lives. And so I really thought that I wanted to bring to the contracts classroom that exact sensibility, that understanding of law and its cultural and historical context, and give students some purchase to be critical of the status quo. And I have to say that I'm sure that a great deal of it was being a beginning teacher and not having a lot of experience in the classroom. But the casebook did become a focal point for my students in their unhappiness with me and with everything that was not law in their eyes, right? So I think you can imagine, to some extent, I think maybe even more so today, as more anxious they become in the job market. But all of their worries about, all of their anxieties about what they needed to know, especially black letter law, focus on what they considered not law, especially things like poetry. So they would write things on their evaluations like, I didn't pay $35,000 a year to read poetry. They hated anything that they detected that could appear to be a feminist perspective or a critical race perspective, and I got some comments about that as well, especially being a young woman at the time teaching it. But I think generally there was just the anxiety of this was something different. It was different from what their And so as a pre-tenure professor, after 3 years of kind of bad evaluations, I got the recommendation from my senior colleagues that maybe I should think about switching casebooks and decide and was advised, try a clean vanilla casebook. So you can just take all of the all of the dimensions of that phrase, plain vanilla, and that's but that is what I did, and I picked a casebook that is edited by one of Pat's colleagues, Carol Sanger. It's the Farnsworth. It's the casebook I learned from, and it's fine, and it is in fact plain vanilla. It's a standard doctrinal, and the recommendation I got was take the standard doctrinal casebook and teach against it. And for me, that ended up being the more successful approach. And so what I ended up talking about in this symposium and the approach that has ended up being more successful for me is sort of, I might say, sneaking in my my humanities, but certainly it's been more successful to me, one, to use materials that are outside the casebook, and second, to put everything in, to some extent, a slightly oversimplified, but I think useful, intellectual historical frame, which to me is actually one that I imported pretty much straight from CLS, Duncan Kennedy, in some ways, which is the rise and fall of classical legal thought. Essentially, I teach the class basically as, or you could say actually rise and fall and rise again, because my class is essentially from status to contract and back to status. So I teach them about classical legal doctrine and the ways many of the contracts doctrines that they learn arose in the late 19th century. I talk about legal realism, rise of legal realism with the UCC and the second restatement, and then I talk about all of the ways that we have resurgences of classical legal thought today, or at least as a law issue. And in the beginning, students found this. I used to constantly get questions like, will this be on the exam? How much do I really need to know about that classical realist stuff? But once that started helping them make sense of the kind of bewildering mass of doctrine, and once the historical, political, cultural perspective actually helped them see a pattern rather than random chaos, they stopped asking, do we really need to know this, or what's going to be on the exam? So by responding to those anxieties about learning real law and helping them to see how history and context could organize and make sense of legal doctrine, I think I kind of won them over. So the dramatic arc of the class traces this transition from classical contract law to realist law. It gives me a chance to talk to them not only about the moral philosophy that underlies classical legal thought and so much of the kind of neoclassical law and economics that they're exposed to in law school, but also to put that in perspective of the history of legal education in the U.S. So the way Christopher Columbus Langdell, Dean of Harvard Law School, established so much of what they're experiencing, not only the case method, Socratic teaching, the modern law school linked to the corporate law firm, the science of law. So much of what they experienced in their first year is this new and alien culture. That's not unrelated to Langdell as the author of the first contract law treatise and casebook, applying his legal science to the problem of the mailbox rule derived from fundamental principles and this idea that there is a right answer to every question. So I want them to see the connections between a certain kind of legal education and practice in this philosophy of legal and contract, and show them the way all these current debates about online contract formation and end-user license agreements that harm consumers, about the parole evidence rule, about mandatory arbitration, continue to be to rush through the last one, use some older ones, and part of that is because of my own, work in the 19th century, and part of it is because I find that with more distance, students can sometimes be more critical, and then maybe they'll bring that into the present day, although maybe not. But I sometimes use, for example, contracts for indenture, so they can see the way something that's part of free contract, right, can actually be bondage and abusive. I talk to them about, I teach them about the statutes requiring freed slaves to enter into year-long employment contracts or be arrested for vagrancy, about actions for seduction, breach of marriage, alienation of affections, and all the hard-fallen actions. And then just generally putting the cases in their context with other kinds of materials. And I'll just say, end by saying that like what Deborah's talking about in terms of gaining legitimacy from some of the other kinds of voices, for me, I start the class with two of the old famous cases, right, Hawkins and Sullivan, because we start with a little overview of damages. And I do two things. One is give them all like trial materials and a lot of the social context of the cases. But the other is to really do the numbers and the efficient breach hypothesis with them, which one scares them and makes them think maybe I am smart, because it's math, and they're great at math. Two, it brings in all those legitimate, economic perspectives, but we start out with a critique right up from the start. They destroy the efficient breach hypothesis, in the first week of class, and then we don't have to have that every single the knee-jerk response every single time. Oh, the market will take care of that. Well, actually, maybe it won't. So I find that also to be really effective. But I hope we can continue the discussion. Thank you.
I'm going to try to be very brief. Yes, I'm Pat Williams. I'm sorry, and I'm so eager to hear what you have to say about Rumpelstiltskin. But I will be very brief. But I actually used Deborah's book and Deborah and Amy's. I've used the controversial textbook. I love using it. I have also used Farnsworth's book, and I enjoyed teaching from that. But I also, my students hated me with both. And in fact, over the 30 years I've taught contracts, I never found enormous success with any particular version of contract. And I think part of it had to do with being perhaps a little older, and there was a great deal of discomfort with me the moment I walked into the classroom. I used Farnsworth when Farnsworth was still the dean of Columbia's contract cohort, and before Carol Sanger got here. And so I think that the dynamics of the law school probably changed a bit. But what I found myself doing instead, I still teach contracts, but I don't teach a contracts class. I am privileged enough to be close enough to retirement that I teach seminars now. So I teach contracts, and I take bids of Farnsworth, and I take a lot of this textbook. And in fact, just after listening to this, I'm actually thinking that I've been doing this as a kind of unconscious use. I think next year I'm going to teach a seminar simply using your textbook. But I teach a seminar called The Anatomy of Autonomy. And as long as I label it something that doesn't violate their sense of genre, they're quite open to it. And I've had a lovely time teaching, The Anatomy of Autonomy, which is a critique of all kinds of contract principles, and a lot of it, and there's a lot of fun in it. But one of the reasons I do this is that I do think that some of the resistance to both the figuration of contracts as contained in a textbook that brings in humanities and fiction and stories, and the figuration of me as a law professor teaching from a classical one that does not, is what is the role of the humanities and why is that so attractive in your textbook? And I came across this passage that Elaine Scarry wrote, and she says that the role of literature, the capacity of literature to exercise and reinforce our recognition that there are other points of view in the world, and to make this recognition a powerful mental habit. If this recognition occurs in a large enough population, then a law injuring others can be passed, after which the prohibition of expresses becomes freestanding and independent of sensibility. Literature says, imagine so-and-so. The law says, we're not interested in your imaginative capacities or disabilities. You are prohibited from the same. But it does seem to me that in the scheme of things, the imagination of the prohibition precedes the law, which says we don't care what you're imagining. And I do think we live in a culture where the ability to imagine a certain kind of empathy, which is embodied at the heart of the study of humanities, is increasingly hard to find. And I don't think this is just a problem with law schools. I mean, it's the way in which our culture has become more and more consumerist. So that when I first started teaching, I was still teaching a kind of contract which was focused upon the analysis of language to construct, or in the analysis of temporality to construct an set of expectations, and we would look at meanings and the layered meaning. There might be multiple meanings at one time. I find that one of the features of the move toward things like law and economics are very reductive kinds of easy numbers of some forms of law and economics, is that people feel the world is completely transparent. There's a symbol for this, and that's all it means. And so my students don't argue with me anymore about, this is what it means, and you're wrong, even. Now they do it precisely in the language that Ariela said, which is that I am paying my $35,000, and I don't want to learn this. So it's shifted from that of a professor-student with the emphasis on what is being professed to a consumerist model, I mean literally a contractarian model, in which I've paid my money, give me what I bargained for, without any acknowledgement of the context. Everything has become, as you use the word more richly, a purchase. But in the academic context, I think that again afflicts not just law schools, not just this textbook. It is the crisis of the humanities generally. It is the crisis of public life, that all of our public life has become so subject to a kind of, and I use libertarianism as a cipher. I don't mean necessarily all of the ideology of libertarians, but a very kind of a kind of philosophy underwritten by I made my choice. You have no stake in what I may have done. But the flip side of that is that you made your choice. Therefore, society owes you nothing. And that reductive school of conscience is not something I'm interested in teaching anymore. And I feel if I can get the point across in other contexts, it's true that they're electives. They're not forced to take me anymore. So perhaps the message gets narrowed, but I do find that that's much more helpful. I'll just there's another lovely little quote that Judith Butler writes about sensate democracies, and she talks about what constituted fidelity, and again the value of literature and the value of humanities. And I don't just mean fiction or literature or poetry, but I think what you're doing in these textbooks, is the rich way in which what contract ought ideally be doing is establishing a relationship between reader and writer, much like the reader becomes then the physician with regard to the textual patient. And that's a very different relationship between, I paid my $35,000, in which money speaks, and the speaker is, has no transaction costs, but the money, yeah. And that, requires, and that kind of analysis in the classroom requires some imagination about the consequences of what we do. And again, the thing I enjoyed most about teaching contracts most of my career was, again, the attention to language, the attention to the syntax, the attention to the lexical dimension that was encoded in the rules. And I fear a great deal of that is gone. Again, part of it is the reductive use of symbols and easy economics, I think. It's much too easy the way in which we have adopted economics in the so-called log economics movement. But secondly, I also think that there is a way in which the multivocality of language itself, and even if it were rather constricted in contract for the last 100 years to a kind of bipolar, voice in contract, has been reduced even further, so that the human voice is almost disappeared now, with particularly embodied in transactions like shrink wrap, in which nobody even bothers to see what they're agreeing. It's like the voice is completely suppressed and disappeared. And we discuss somewhere at the surface about what it means to assign risk, not really set expectations, but to assign the risk of what we have no knowledge of. And this is an enormous sort of ceding of power, or at least a dispersing of it, so that nobody becomes accountable for anything, because if you actually did press not just I agree, but first print off terms of service, print off privacy policy, and read the 40 pages. I will just end by reading you one of the paragraphs from the license grant on edX, which nobody reads, but everybody's taking massive online courses in schools themselves, and this is not just, but it is anybody who takes a move, has to sign, or has to get on by saying I agree. You should really print off the 40 pages of terms of service, the 20 pages of the privacy, but just the license to grant. So when you do your user postings, when you're discussing with supposedly the professors and at the exalted institutions, you hereby grant to edX a worldwide non-exclusive, transferable, assignable, sub-licensable, fully paid up, royalty-free, perpetual, irrevocable right and license to post, transfer, display, perform, reproduce, modify, distribute, redistribute, relicense, and otherwise use, make available, and exploit your user postings in whole or in part, in any form, and in any media formats, and throughout any media channels now known or hereafter developed. And this is familiar language, I suppose. But the question for me is, this is suddenly part of an entire educational enterprise that is scheduled to take over certainly the humanities, certainly the attack on universities is accompanied by a sense that we can now all have core curricula, reduced presentation of almost any course in the world, which will be mechanistic in the sense that what's happening now is that that universities like Columbia, including my own university, are basically encouraging using their names. They're branding these particular programs, so that when you read them, what you realize that is they're supposedly free. They're not free. What they're collecting, as with any online enterprise, is the big data out the back door. And so when you actually look at edX's, if you look further, what they are doing is, you also agreed there to become an experimental subject, a human research subject, which bypasses all of the human research conventions that most schools would otherwise ordinarily put in. So you have people all around the world becoming human research subjects, and then this material is trolled, quote, for how people learn, by neuroscientists, for how people learn. And then it will be packaged, resold, and then you will have curricula in which basically what you're beginning to see in places like the Third World, which is billed as an unqualified, wonderful thing, democratization. But basically you have curriculum where you don't need teachers, you simply give them an
we'll see what they think about that. But I guess my topic today, or the title of my topic would be Magic Always Has a Price. Rumpelstiltskin's bargains in Once Upon a Time. And I want to use those bargains to raise some browse wrap issues. So I'm happy also to see Nancy and other folks here, Nancy Kim, with her latest book on wrap contracts. It's going to be tomorrow's panel session. Because I think that's a really pressing issue. And Pat just mentioned also that problem of user agreements, terms and conditions that we don't read anymore because we know we can't change them. And that was actually one of the questions on the contracts final last semester was a browse wrap contract. So anyway, popular culture. I always use popular culture when I teach, and there are so many reasons to use it. I'm just going to mention 3 pedagogical advantages of using it. One is that lawyers are storytellers. We need facility with narrative. We need to be reading stories and interpreting stories and telling stories. And as far as popular culture is concerned, litigators have long known that we are better communicators when we know and can refer to the stories that our audience knows. Okay, second reason, cognitive science suggests one of the most effective ways to teach a new concept is to help students connect that new information with something they're already familiar with. Second reason, communication studies indicate that if information can be coded redundantly, that is if you can, for example, use words and images and music and add things on here, the more you can be redundant in coding the information, the more likely we are to remember it. Okay, so once you're in law school, and especially I'm going to talk to the students here, I bet that you started seeing the world through a very legal lens. And you would look around and say, oh, there's a tort, there's a contract, there's all these different issues that I just never realized were there before. And one way that you can sort of use this new lens, this new vision, is to look around in popular culture and perhaps practice identifying bargains. So, hence the Rumpelstiltskin analogy. A recent television show, Once Upon a Time, is now in its 4th season. It's been picked up again for another season. It takes place in the small town of Storybrooke, Maine, whose residents are characters from another realm. They are from the realm of fairy tales. And the show alternates between the real world and the fairy tale world, with each character having a dual identity. So that Rumpelstiltskin in the fairy tale world is also Mr. Gould in Storybrooke. And the show is kind of bonkers. I mean, it's this mashup, and you might have Captain Hook and Snow White's bounty hunter daughter all together in the same storyline. But it's really fun, and Disney is trying to tap into a particular synergy and some of its princess products and so forth. But at its heart, it is a show about bargains. Now, bargains are central to many fairy tales and to folklore and to mythology. We can think of a lot of examples. We can think of, Jack trades a cow for some magic beans. Okay, well, the plots of Once Upon a Time are stuffed full of contract issues: offer, acceptance, consideration, modification, unconscionability, revocation, breach. But I was struck by the fact that many of these bargains seem different from the traditional fairy tale bargains, as far as whether the participants fully understand what they're getting into. When the Brothers Grimm, who themselves were law students, by the way, they were former law students when they started to go out and collect the fairy tales, when they published their collection of Germanic folk tales in the early 19th century, the bargains were very specific. Rumpelstiltskin makes 3 very specific bargains with the miller's daughter in exchange for him spinning the straw to gold. The first night, the deal is for her necklace. The second night, the deal is for her ring. And the third night, she has to promise to give him her firstborn child. Okay, so it's escalating demands. It's very sort of common in fairy tales, but they're very specific. It's clear what you're getting into. Now, in contrast to the pretty specific deals in traditional fairy tales and folk tales, even deals with the devil, where you're giving your soul for wealth and power, but you know that's what you're doing. The television deals involve apparent agreement, but the parties don't fully understand to what they are agreeing. They say over and over, we have a deal. But how can you have a deal when you don't know the full price you will have to pay, even if you understand that magic always has a price? Okay, the nature of the deals typically involves information, magical knowledge, sometimes in the form of a spell or a curse, and the promisees are usually desperate for the knowledge. And here's some of the things that is said about the return price. Mr. Gould says, well, how about we just say you owe me a favor? Or I'm sure we'll find some way for you to pay back what you owe. Most interesting of the deals are where a great boon is exchanged for a seemingly small favor. And the small favor turns out to be worth quite a lot. For example, Rumpelstiltskin gives Snow White a forgetting potion in return for a single strand of her hair, which seems like nothing, but it can be used to create the most valuable magic of all. Or Cinderella promises some later favor, and then Rumpel extracts a heavy price later on, which is her child. Now, we would never agree to such bargains, right? I mean, well, wait a second, though. Cows have contracts. Particularly the terms and conditions, the user agreements, the privacy terms. Ironically, they're often called privacy terms, and you're giving up your privacy. But just as in fairy tales, information is valuable. And in our new information economy online, where consumers agree to give up privacy rights in order to use the magic of social media and the internet, it turns out that those two terms that we do not care to read give up some very valuable things indeed. Users' data can be acquired for very low costs. It costs about ½ cent to acquire some of these. But the average value to internet advertising is $1,200 per year per consumer. Okay, well that's interesting. Is that consideration? ½ cent, $1,200? It seems kind of strange. Well, how many people read the terms and conditions? Whenever we ask these questions in class, the answer is usually 0 to 1. But we're being rational actors. Why bother? We know we can't negotiate. We know we can't change the terms. And there are, in many instances, there's no choice. We really want this. We want to be able to use this particular social media. Well, will the market fix this? I don't know. There's a lot of overreaching going on now. It seems to be the norm. Is there any hope for perhaps a good fairy? If it's not the market, what's it going to be? And can we perhaps expand Section 211 of the restatement? Are we going to perhaps use the doctrine of unconscionability? Can we try arguing with good faith? Magic always has a price. But if we use the magic, have we freely assented to the price? I just want to show you one quick little clip from the show for those of you who aren't familiar.
Down and look at it.
It's going to be, oh, sure. It's going to be on 3 screens, so yeah.
So you can see
Yes,
it.
but they're
Oh, yeah, but they're behind
us.
So just a quick little clip just to get you in the mood. I think a lot of people have seen this, but it's a meme. It's almost a meme where people will say in the show, magic has a price, and then the deal is cut. Magic has a price, and then the deal is cut. And they even have T-shirts now that say this magic always has a price. So let's pull up one of these. And Rumpelstiltskin in this first part of the clip is very, very desperate. That's the reason he's taken this particular deal. And the person who has given him this magic says, I can recognize a desperate soul. So that's why I picked you.
Comes with a price. Go on back to your life. In fact, your lucky stars, you still get something to go back to.
Quill, I don't understand.
The blue fairy cast a spell on it. Whoever signs with this will be frozen, their magic made impotent.
All you must do is get him to sign the contract. This man is a scourge. We're doing the entire land a service.
Should we even use magic? causing these problems to begin with? What if this magic also has a price?
Then I will pay it. I will do whatever is needed to save you and our child.
What a lovely quill. Wherever did you get it?
It's from our castle.
You know, the only way to stop me is through magic.
I'm not trying to stop you.
Of course you're not. Because as we all know, all magic comes with a price. And if you were to use it to say, imprison me, then your debt to me would only grow. And we wouldn't want that now, would we?
Just sign the contract, please.
Are you sure you're happy with this new arrangement?
What did you do?
Oh, what's wrong?
Your Highness, what happened?
What did you do to my Thomas?
I haven't done anything. In case you haven't noticed, I've been otherwise engaged.
Something's happened to him. You know, tell me.
I've no idea, dearie. But I did warn you. All magic comes at a price. It looks like someone has just paid.
Listen to him. We'll find Thomas.
You get the idea. So there's this theme of magic always comes with a price. And this is a show that is chock filled with bargains. Lots of bargains. And bargains where people don't always know what they're getting into. Okay, so we're going to probably do some.
Oh. I guess so. All right. I don't know if we have to go back up. Yeah. Oh, they're recording. We have to.
So in the spirit of Lenora's presentation, keep rally, you and I'll listen. I think Rumpelstiltskin clearly had an insufficient knowledge of popular culture, because he should have done better than to ever take anything from Brad Dourif, the actor, who always plays a villain, usually a psychopath. Had he only been more aware of who this was he was dealing with, he might have.
But he was desperate.
He was desperate. You have to be pretty desperate to get in a deal with Brad Dourif.
I'll throw in my own bit of pop culture. I cherish a T-shirt, Pearls Before Swine. Some of you probably know that. The Crocs are in hell, and they're talking to Satan, and they don't know why they're there. And Satan says, "Will you sign this paper?" And the Crocs said, "Well, I thought I was just going to get a pack of gum or something, and I've signed away my soul." And Satan says, "Well, you should have read the fine print. I am, after all, Satan." That always sums it up for me. When you're talking to the drafter of the contract, remember you're talking to Satan.
Any other questions?
Well, I just had a little comment, I guess, to add. It was interesting to hear, I wasn't surprised, but I thought it was interesting to hear the negative student reactions to your introducing sort of literature in the classroom, because it seems like sometimes, like I tend to be very, because I'm afraid of this kind of backlash, and because I do need to present in a certain way and be as sort of traditional as possible for all the reasons that you are familiar with. And, it does seem like when I do introduce a little bit of pop culture or a little something from literature, the students love it because they pay attention. And so sometimes what they say is not necessarily, it's interesting to me to hear that counter.
I think I should make 2 points clear. I don't know about Ariela, but I've never had a class where uniformly everybody has resisted what's in the casebook. There are people who love it. I got fan letters, right, from students who are at other schools about, this was the most wonderful experience in their life reading whatever it was that they read that was in the casebook. But I don't want to generalize. there is it's gendered sometimes, right? That the resistance to fiction, right, is often on the part of my male students. They don't want to read it, and the fiction is enjoyed much more by the women who are in the class than it is by the men. They just don't want to read it. They see it as something which is irrelevant, right? If it's well, we have newspaper articles, we have historical documents. The Puwaiki case has the Takaki piece, right, as I said, and I will say that you can't reach people who don't have a level of self-consciousness about their own issues. And the alumnus who wrote that memo, right, I'm saying, okay, so he was made to read something written by Takaki. Is that right? Takaki, the historian, right? And he's being taught by a teacher named Oda, right? And it's about Hawaii, right? So, you know, we used to talk about unconscious racism, right, in the past 20 years ago. We dealt with it. But to try to get sometimes you can't reach a student who's not self-conscious about his own personal reaction to things. And you do what you can, right, to make it transparent, obvious, or to talk about it. Like, you know, the case, the good faith case about the bank, Key Bank in Maine, right? And so, which you don't use anymore, Jack, which is
What's that?
the Key Bank case with the man who brought the Reed case. So it's problematic on lots of different levels, but basically what was interesting to me was that the jury found that there was no violation of the race discrimination statutes, but there was a violation of the duty of good faith, right? So I look at that and I say, at some point in our history, being a racist became equated with a moral wrong. I do think, right, around the time of the civil rights movement, Martin Luther King, right? Now you can't without some sort of reaction use racist epithets, right? No one wants to be called a racist. And so I want to say, like, it was so much easier to say there was a breach of the duty of good faith than it was to say that this bank was guilty of racist behavior, right? But the basic premise for the lack of good faith was no one else had ever been treated that way except this one black man, right? So that to me was, a clue. But having conversation, it's still difficult having conversations about race. It never ceases to be difficult. But the composition of our classes has changed too, so that should make it easier, but it doesn't always make it easier.
The composition of your classes has become more diverse in the last 20 years.
Yes.
I think that's not true for us. I mean, USC is actually one of the most diverse, racially diverse law schools it's definitely the most in the top 20. But I think the last few years we've gone the other direction, unfortunately, in some of that. But I'm not sure that I would have that comparison, that would work as a comparison. I think that it may be up and then back down.
So, are we supposed to, so I'm Debbie Hart, I teach contracts at Southwestern, and I guess I had a question. One, so I was wondering, Ariela, just as a comment off of your last comment, whether or not, even if it's racially diverse, if it's socioeconomically diverse, and I'm not sure. I'm curious about that. But then I guess I was also wondering, just as a general matter, with respect to incorporating humanities and popular culture and things like that. So on the one hand, it seems, I understand, Lenora, what you were saying, and it's easier for me to grasp. I can see how you can use popular culture and clips and things like that in order to help students relate to and therefore understand a particular concept that they're learning for the first time. So that part, I think, is fairly straightforward. And I'm not saying that that's all you do or the only reason why you do that, but that seems fundamentally different to me from what Pat was talking about in terms of this need to have humanities, not just in the contracts, but this is what we all teach here, but in contracts, specifically to remind people about the importance of imagination, just to summarize, just to the gay concept that we focused on, which is a different purpose. That, not that they're unrelated, but there has to be a way to think about how to do that, the imagination part, and why that's important I can bring in Pirates of the Caribbean to show the big old contract, or The Hobbit, right, to show the contract and things like that. That's very different. And I guess it's harder for me to think about how to do the imagination part. And I'm wondering if there's ways that all of you, I know Keelan thinks about that. Huh? I can quiz her on the plane. But you know, how do you, is there a way to introduce this slowly, you know, or something? Yeah.
I just, I thought, I really agree with that point. I find it, the pop culture stuff much easier, where there's so many great examples of movies with short clips where, of course, students, that have somebody making a deal that you can, and illustrates the point that you can use. Students always love that as a great deal, like a break, but it's also like a different way to do a hypo. I see those as different as well, less challenging. And the materials, it's not just that they're filmic, although that helps, but as opposed to, you know, if you showed them The Handmaid's Tale, for example, right, I don't think that would be the same easy, fun hypo that we feel doing, like, the big C giving up cigarettes, you know, bargain. And so, to me, it's the part of the thing that they're resistant to, right? The thing they can't see, I didn't pay $35,000, is often the very thing that we're trying to get across, and that some people, as Deborah says, aren't reachable with, but maybe there's some group that is. I would hope there is, and that's what I think the idea of getting across the voices of the people who aren't heard, getting across the critical. I mean, I think they're right to make the connection, because I think we are often trying to make the connection between the genre of humanities and outside cases, and not only a perspective, but voices of people that they're not hearing, and for those people who want a conventional, you know, hegemonic narrative about contract law, just give me the black letter that is, you know, the law. They don't want to hear those. So I don't think it's a mistake that there's resistance. I'm not saying that there aren't ways to communicate to many students, but I just think that it is connected. It's both that what is valuable about the humanities is also challenging. If it weren't challenging, we wouldn't want to try to keep it right.
And I that's a point, you know, at some point, this is the consumerist mentality, but I don't know, I run into it a lot now in legal education, and we, at the ALS meetings when we've had the hearing with the ABA, Council on Legal Education, the whole alteration of the way we think about education is being something where we are providing students with knowledge, right? And sometimes you may not, sometimes it's not pleasant learning something, right? Sometimes it's hard work. Sometimes it's not what you want to do, but all of a sudden it's become, no, we have to give them what they want. And it's not about what they want, it's about what they need, right, in order to be good lawyers. And I don't know when we made that switch from what they need to be good lawyers to what they want to hear. But Hila, you had a question, so I'm gonna call you.
No,
Carol, I guess.
I'm just thinking maybe we're taking the easy way out for ourselves, because I feel there's something about thinking about the students that strikes me as, I'm fascinated by the point about the commercialism and one economics being so reductive and so harmful. And I think what is in this story is this affirmation of being selfish. And what I'm talking about is easy way out for ourselves, because I think the whole problem that we're circling around is the teaching evaluations. And teaching evaluations are really part of this paradigm of the market, because this is part of what, and there is a conflict, I think, between taking the humanity-framed outlook and developing empathy and living in this environment that has it and has imagination in it, versus in my first year of teaching at Southwestern, I was untenured, and in my teaching evaluations, I got complaints about this law, right? But I had a dean that lived in Law and Society, and he wrote back after seeing my teaching evaluation, this is exactly what I want to see, right? And so it's really, and we all want to make them happy and feel this selfish need for pleasure and affirmation, but I feel as if we don't need to succumb to that. So, for example, I'll just give one example. When my first reading assignment in contracts is a story, a short story by Maya Angelou, It Wouldn't Take Nothing for My Journey Now. And I put this Ms. Johnson at the center to just project all the ideas of an active agent who is a woman and African American in other days, so it's history and it's all that, just to convey the theories behind contracts, why contracts are useful, justified, and these are all classical ideas. And whether or not they love the idea, I think I care selfishly, but I shouldn't care. So the point is humanities versus markets ideology.
Can I just jump in for a second here? I was thinking that with the, everybody's talking about.
I'm keeping lists, Jane, you got it, you got it, okay.
Complaints about fiction not being law. You know what? There's already fiction in a lot of the case books. If you look at hypos, and it's actually bad fiction. It's like, A buys black yogurt and sausage. And in the problem-oriented case books. So, I mean, there's fiction already in there, and sometimes a better fictional story can catch the imagination and engage the students. And we might have to take the long view, because I always start with a poem. I always start the semester with a poem, and I end the semester with a poem. And lots of times students tell me, like, what was this poetry stuff? I don't understand why would we. I had a student who came back 3 years after she graduated and said, you know that poem that you gave us the first day of contracts? I didn't understand why we were reading it. It was a C.P. Kabafi poem called Ithaca. And she said, now I framed it and I hung it in my office because I really get it. I get it now, but it just takes time. So sometimes you have to take the longer picture.
So it occurred to me that part of the resistance, and I used the casebook for a few years, and I had some of the same resistance, and I think some of it is, it's hard, you have to teach differently, you have to do something and figure out how to use the material, and I don't think I did that so well, so I don't blame the students entirely. But some of the resistance is a sense that you're making a political point with the material, that the teacher is and using it, but that the more direct, we were talking in an earlier panel about trying to be more transparent about what we're trying to do with them. And one of you talked about teaching legal storytelling, I think, somebody did. And I mean, it seems to me that this is part of it, part of the value of literature is judges and lawyers tell very thin stories. And if you're trying to get across the story of your client, if you're trying to be persuasive on something, you have to tell a more complete story, and you have to learn how to do that. And one of the ways to learn how to do that is to see how other good storytellers tell stories, and how the voices that are in those stories somehow, how do you turn that into the right story? When I was in practice a long time ago, one of the partners in my firm would talk about, he'd make a final argument he made where he was trying to explain how the witness was probably being paid by or getting something back from the prosecution, and that's why that. Well, he didn't just say that. He told a story. Now, he was from the South, and he could do this, and I couldn't do this myself in the same way. But he painted a picture of the chained bear, and then the person who was running the show just yanking on that chain, and it's like, whoa, that helped, And so if we can somehow use those, explain that that's part of the value of it, is that those voices are missing because the people who write legal stories aren't very good authors. And if you're a better author, you can do a better job. So it's just a thought.
I think Carol answered my question a little bit, but I was going to ask if you've had, one of the ways I find that, and I don't do it nearly enough or very well, but that students, to hit on what students as consumers, right? And sort of flip what you are consuming and why you're here. So to be a storyteller, right? Learning to be a better storyteller. some of the problems that you all have, and I use Chuck's book, and there's some opportunities to do this as well, but how do you find students respond to thinking about the other when it's someone you're representing? And if that's an avenue to try to bring some of this in a way that they may see some relevance and then be more open to exploring, if you've had any success or not with that.
All right, I'm now gonna confess a failure because it would be, but I'm hoping that, doing this more and more often, I at least try. It's just about trying, okay? So, in this political climate, unions are not looked on favorably. And one of our big cases is a case, Dayton Malleable, right? And it's a case where the union brought a suit, and their argument was that a promise had been made that the plant would not be shut down if the company undertook, right, the transformation from one form of manufacture to another. That's all we need to know. And what they had to do this was to persuade the workers to agree to changes in their union contract. So they held a mass meeting, right, and the great thing about the case is that the court, in the case, they have appended to it exactly a transcript of what the president of the company said to the workers, including the questions that the workers asked of the president and the responses that he gave, right? So on occasion, not every year, but on occasion, I've actually had them play this out, right, with them taking the roles of the various union workers who were asking the questions and somebody playing the part of the president of the corporation and reading the speech, right? So they're listening to it. And this is all about, we've already talked, because we did 1330, about putting yourself in the shoes of the recipient of the communication, right? So you're receiving communication from somebody, can you, and this is an act of imagination, put yourself in that person's shoes. So it's not just can you represent your client, it's also even in applying a doctrine, right? Thinking about what a reasonable person in that position would have done. So I will tell you that it is very, very hard to break down a belief system, right? Or to get people to imagine something other than how they react. Because in this transcript, there's a very explicit statement. An employee says to him, are you saying, right, that if we begin the conversion, the plant won't shut down for 2 years? And the president says, yes, that's what I'm saying. But the decision says that everything the president said was equivocal. It was all sort of qualified, that there were ifs, ands, and buts, there were maybe it'll happen, maybe it won't. But I, listening to the transcript, right, say, there it is, right? There it is, an explicit promise. Once we start the conversion, the plant won't shut down. But I'm listening with the ears of a woman who's the daughter of a steel worker, right? So I hear it. My students have grown up in an environment where they think that business should be able to do whatever they have to do, right, to make a profit, and they said they weren't making a profit, and so they get to shut down the plant. So I'm just saying, I don't think it hurts to try, right? I think it's important for me as an educator to try to get them to imagine another life experience, right? And to see and hear things perhaps the way that person who is more different in a different social situation or setting, what we call socially situated reasonableness, right? Who a different socially situated person would hear and understand it, right? So the fact that I failed doesn't mean that I failed. I've at least tried, right, to get them to imagine. And gosh, isn't that really what teaching them to be lawyers is all about? It's gotta be about imagining the reasonable person if you're a judge in that position. I don't think Judge Lambros did a
class, and it was the black letter law. I mean, it was case after case after case after case of black letter law. And I'm kind of like, okay, but I'm thinking this is not really how it works in the real world. I have purchased, and I have bought, and I've tried to write stories about two sides. And I know I'm supposed to be advocating one side, but then I also have to look at the other side. And then it was black letter law, black letter law. So I felt like I had to shut down what I knew as a person and just learn and try to become this lawyer. And thankfully, I was able to turn it back on right before the exam because I knew that that was just going to help me. I had gotten the law down, that was fine, but I needed to turn on the common sense. I needed to turn on the storytelling and the persuasion in the analysis because I knew that that was what's going to get me points. And I have the pleasure of being a Professor Ledwon and I went from a classroom of very black letter law, to a classroom of black letter law, but also more of an open realm of thought. And it's like, she does such a good job about it. And I know a year of contracts and I love to learn, you know, even most of it. But then I also get another perspective with it, how she presents it, the casebook that she's using. And it's like you step back and you look at it and you're like, well, I can use this in my arsenal. I can use this. And yes, I know the law, but at the end of the day, I'm going to be telling, you know, the story, and I'm going to be pleading my case in front of people. So I should be able to have to say something that will resonate in addition to using the law. Because sometimes I might not have the law on my side. I want to use the facts. And the facts I'm going to have to use with the story that I'm going to tell, and I'm going to have to be persuasive about it. So I was able to turn that back on with all the experience I had prior to law school and just realize that, okay, I need to know how to mesh these things together to try to become a good lawyer. So I really appreciate that we had this panel and we're discussing all these different things, and I'm able to sit in Professor Ledwon's class and see how she does it, because it relates to becoming a lawyer and telling the story.
Thank you. We're going to give Amy the last word because it's almost 12. The bus is going to.
That's fine. Give me your last word.
Okay.
I'll be short.
Okay.
And I'm not speaking as a representative at all. We have differences, but I want to say that I think that our responsibility also involves our understanding of what law is in a democracy. And I guess I want to confess to my love for democracy and my recognition of the potential conflict between law and democracy. And I believe that our students, when we hear our students wanting black letter law, when we want clarity, when we want what's really legal, and I want to say this in as gentle way as possible, I believe there's a longing in any democracy for authoritarianism. And I believe that that's been a part of our history for centuries. And it's a mistake to sort of buy into the idea that law is necessarily authoritarian in a democracy. And so I think we have to teach, I think we have to teach our students the connection between what we know as contract law and the values that are deep within our numerous different communities, different values that are within our different regions. And I think we should invite them into this struggle about what does it mean to have a democracy, and what does it mean, hopefully, to be able to retain some of our diverse cultures in that democracy. And so to me, it's like, what are we teaching? And if we're teaching that law is authoritarian in black letter, I think I don't want to be a part of that project. So that's the struggle for me, as to how to teach that understanding of what the law is.
So I did see the shuttle